expert panel here to discuss these issues in greater detail. I'm not going to give you their full, lengthy, impressive bios since you have those available in your programs here today, but just very briefly. Bob Barr is a former member of Congress and also relevant to today's topic is a former United States attorney and a member of our Liberty and Security Committee. Peter Eckersley is Technology Projects Director for the Electronic Frontier Foundation. He is our techie for today's conversation, and he is an expert in privacy and security projects. Professor Jeffrey Rosen is Professor of Law at the George Washington University and also the Legal Affairs Editor for the New Republic. And also relevant to today's conversation, his most recent book, for which he's co-editor, is Constitution 3.0, Freedom and Technological Change. And finally, Jason Weinstein is Deputy Assistant Attorney General in the Department of Justice's Criminal Division, where his responsibilities include overseeing the division's computer crime and intellectual property programs, and he's also served for quite a number of years as Assistant United States Attorney in both the District of Maryland and here in the Southern District of New York. So the way we're going to proceed today is first, Professor Jeff Rosen will provide an overview of the Jones decision, including all three opinions, and share his views on what he sees coming next and the challenges going forward. Next, Peter Eckersley will provide our techie perspective and share with us about some other technologies, in addition to GPS, that are already out there and coming soon, and their impact on these issues. Third, Congressman Barr will talk a little bit about the Constitution Project Liberty and Security Committee's report, as well as his thoughts on challenges going forward for incorporating these kinds of privacy safeguards. And finally, Jason Weinstein will provide the government's view on location tracking and when warrants should be required, and also reflect on the respective role of the courts and Congress in this debate. After they each make brief opening remarks, I will moderate a little bit of a conversation among them, and then I will open this up to you, the audience, for Q&A. So we will start with, thank you.
Thank you so much. It's a great pleasure to be here. Thank you all for coming. So the Constitution Project, in its bipartisan spirit, has asked me to sum up the three opinions in the Jones case as neutrally as possible. And I will do that. I won't display a hint of what, of course, I actually think on this case, except to say that this is an occasion for modified rapture. It is an extraordinary achievement that the Supreme Court, defying expectations, unanimously rejected the extreme position of the Obama administration and several lower federal courts who held that we have no expectation of privacy in public. A position that, had it been accepted, would have dramatically reduced the amount of privacy that citizens have in the 21st century to give us far less than those in the 18th century took for granted. But the court disagreed about the best way of protecting privacy, and let me briefly describe the differences among them. On the facts of the case, you recall that the cops are investigating a guy for dealing drugs. They put a GPS device on the bottom of his car after obtaining a warrant, but they are supposed to serve the warrant within 10 days. In fact, they put on the device on the 11th day. They're supposed to only track him in DC, and in fact, they track him in Maryland. So for the purposes of the case, the court has to assume that there's no valid warrant. A lower court had rejected the GPS information that had been obtained while his car was parked at his home on the grounds that that was private property, but had admitted the tracking that took place when he was away from home on the grounds that he has no expectation of privacy in public. And that was the position that the Supreme Court unanimously rejected. The majority opinion, written by Justice Scalia, focused on the fact of physical trespass. The police had to attach the GPS device physically to the bottom of the suspect's car in order to track him, and Justice Scalia said any interference with someone's property interest at the time of the framing would be considered a search as long as it was used to obtain information. So it was those two factors, the interference with the property or possessory interest and the intent to achieve information, that, in Scalia's view, triggered the Fourth Amendment and made this a search. Now, the opinion has been misread by some to suggest that a warrant is always required whenever there's a trespass. Scalia didn't actually say that. He said that the government had waived the argument that the search might be reasonable without a warrant, and therefore he wanted to exclude the evidence in this case. But it's possible that Scalia might, in future cases, come up with an exception to the warrant requirement in cases like this. The insight or contribution of Scalia's opinion was to say, it's true that the court has moved away from private property as a test for Fourth Amendment violations, but Scalia said property is a floor, if not a ceiling. At the very least, if there's an interference with property interests, then a search is presumptively triggered. So that was Scalia. Justice Samuel Alito, in a far more sweeping and creative opinion, took issue with Scalia's focus on physical trespass. He noted a series of anomalies that are sure to arise in future cases. Alito said the government in this case could have achieved the same information without physically attaching a device to the bottom of the car by subpoenaing the LoJack device that's embedded in the car and also tracks its movements. Or in future cases, the government might require that GPS devices be embedded in cars and then obtain the information without a physical trespass. Or more relevantly, Alito said the government can avoid the idea of affixing devices or subpoenaing information from the car entirely by subpoenaing the same information from cell phone companies who hold third-party geolocational data, which at present is unconstrained by the Fourth Amendment. So for all those reasons, Alito said that a focus on physical trespass fails to protect the real privacy interest at issue in this case. And Alito understood, in a pragmatic sense, that ubiquitous surveillance for a month can reveal far more about us than a snapshot of someone's movements for a day. Alito said that our intimate associations, the books we read, the people we associate with can all be revealed by ubiquitous tracking, and therefore people do have an expectation of privacy in the whole of their movements. And then Alito proposed the following test. He said that long-term surveillance presumptively requires a warrant. Here's his language exactly. He said that relatively short-term monitoring of a person's movements on the public street is presumptively okay without a warrant, but the use of longer-term GPS monitoring in investigation of most offenses is no longer permissible without a warrant. And Alito recognized that he couldn't identify the precise point at which short-term surveillance becomes too much. He couldn't identify the Goldilocks point, but he said that when the police are unsure, they can achieve a warrant. So this was a tremendously important and insightful opinion. It shook free of the wooden notion that short-term surveillance is the same as long-term surveillance. It opens up the possibility of meaningful constitutional regulation in the future in cases that don't involve physical trespass, but it still left lots of undecided issues. And some of those issues were flagged by Justice Sonia Sotomayor in a very interesting, separate, concurring opinion. Now, some people were surprised that Justice Sotomayor, who in some ways took a broader view of the privacy interest in the case than even Justice Alito, didn't join Alito's opinion, but instead joined Scalia, depriving Alito of the majority. But Sotomayor said, because it was possible to decide the case narrowly, you could save the broader questions for future cases, signaling her willingness to re-examine them in the future. And for Sotomayor, she focused on what in practice people would expect. She said most people, although they might realize that they're being tracked on some theoretical level, don't actually expect their intimate associations, their movements, their books, and so forth to be revealed to the government and exposed to the world. And therefore, Sotomayor signaled a willingness to re-examine the third-party doctrine, which, as we'll discuss, is in some ways the greatest barrier to meaningful protections for privacy in the age of new technologies. The third-party doctrine says, arose in a case involving the privacy of bank records in the 1970s, and the court said that when I surrender my financial information to a bank, I abandon all expectation that the bank won't surrender it to the government. Essentially, I turn over information for one purpose, I've abandoned all expectation of privacy in it for all purposes. That decision was so counterintuitive that Congress overturned it by statute. It goes against the grain of the European Union, for example, which says that information disclosed for one purpose may not be disclosed for another without the consent of the individual concerned. But Sotomayor recognized that in an age when all of our geolocational data is stored by third-party cell phone companies and internet service providers, without re-examining the third-party doctrine, it won't be possible meaningfully to restrict geolocational tracking. So her willingness to re-examine that was important for the future. All right, so those are the three opinions. What are the undecided cases? The big one that's coming down the pipeline is cell phone tracking. So the New Jersey Supreme Court in the Earls case has just agreed to review a lower court decision holding that we have no expectation of privacy in geolocational cell phone information. That basically, once I voluntarily use a cell phone and reveal my location to the cell phone, I've abandoned expectation that the cell phone information won't be revealed to the government. And the Ninth Circuit in California is about to examine that question as well. The cell phone question both raises statutory questions that we'll discuss involving the possible amending of the electronic privacy statutes, as the Constitution project has suggested, but it could also raise constitutional issues if the court were willing to re-examine the idea that information disclosed for one purpose may be broadly shared for another purpose. There will be issues involving intrusive surveillance on city streets. I was distressed and interested to read just this week that New York City is about to start implementing naked machines on the subway. That basically the New York police, when they suspect terrorism or drugs, may use the kind of portable naked body scanners that are used in airports now to reveal not only contraband or weapons, but also graphic images of the naked body. And the court may have to examine the question of whether an especially intrusive search in a public place might require a higher degree of suspicion than a less intrusive search, and also take up a really interesting question flagged by Justice Alito's concurrence, which is that intrusive surveillance or even long-term surveillance might be reasonable when it's focused on terrorism or serious crimes, but unreasonable when it's focused on low-level minor crimes. That was a very interesting insight that Scalia jumped over because he thought it was too subjective. But ever since the time of the framing, the court had allowed for searches of private papers, for example, to investigate murder, but not to investigate seditious libel. And if the court is willing to allow certain forms of intrusive surveillance for serious crimes but not low-level crimes, that would be helpful. There's a case pending before the court this year raising the question of whether you can be strip searched if you're arrested for a misdemeanor or for a traffic offense. And if the court says no, as some people hope and expect, then that combined with Jones might provide an opportunity for limiting intrusive surveillance to serious crimes. Then there's the Google question, which is endlessly fascinating. I was at a conference at Google a few years ago, and the head of public policy said he expected within a few years Google will be asked to put up all public and private surveillance cameras in the world and link them on Google. And if Google and also Facebook did something like this, Facebook already has little apps along these lines. You can sign up to Facebook and look at live beach cameras in Mexico, which are popular with teenage boys for reasons you can imagine. Imagine if Facebook links the beach cameras to subway cameras in New York, to metro cameras in DC. Basically, you could sign on to Google and Facebook, click on a picture of me, back-click on me to see where I'm coming from, forward-click to see where I'm going, and have 24/7 surveillance of everyone in the world at all times. And if that system were to be implemented, the gap between the Scalia and Alito opinions in Jones would be squarely presented, and the court would have to determine whether long-term surveillance without any physical trespass, exactly under what conditions it can be regulated. And then finally, there's a whole series of equally crucial questions involving ubiquitous surveillance by the private sector. Google and Facebook, after all, are not the government. They're not formally constrained by the Fourth Amendment. If Google or Facebook put up this open planet system and it was used by purely private parties, it doesn't raise Fourth Amendment issues, but should it raise questions of tort law or statutory questions? And drone surveillance will raise this issue as well. The great issues of drones in the future won't only involve the targeted assassinations that we're now properly focused on, but the use of the private sector to send up drones throughout the air to surveil our location and send us ads on the basis of them, possibly even to go into, fly into private homes and take pictures and fly back out. And the drone question, for me, raises the question that I want to end on, which is, what do we do in a world where technology is moving so fast that a constitutional test that depends on what people actually expect is bound quickly to eliminate constitutional protections? So the court, even Justice Sotomayor, as well as all the other justices, say the relevant question is how much privacy people expect in the light of proliferating technologies. And in a world where 24/7 Google surveillance or drone surveillance may soon be a reality rather than science fiction, that sort of test would basically guarantee that we have very little constitutional protection. I don't have the answer to this question, of course, but my instinct is that to really protect as much privacy today as the 18th century founders took for granted, the court will have to get away from this idea of empirical expectation of privacy and embrace something like Justice Harlan's concurrence in a case called U.S. v. White from the 70s. Harlan said the question isn't how much privacy people subjectively expect, but how much privacy citizens in a free society should be entitled to demand. And that question, that normative question, is harder to identify. Judges may be reluctant to draw those lines, but unless they do, I fear that the privacy protections so encouragingly flagged by U.S. v. Jones may quickly be defeated by new technologies. Thank you so much.
Thank you for a great introduction. So I'm going to talk about location tracking, what the data sets that you get from location tracking look like, where they come from, and what kinds of concerns they raise. And I'm not going to focus exclusively on the Fourth Amendment and on law enforcement access because, as Jeffrey pointed out, we're building a lot of pipes to move this data around in a lot of different places, and there are concerns that come from that are sometimes about the fact that a law enforcement agency may be able to go and tap into one of those pipes and get a stream of information about a particular person and where they are. But also, these are wider societal concerns about this infrastructure and the kind of privacy that we're going to have in the location tracking era. So I'm going to talk first of all about location data. And I'm going to talk about idealized location data. If you talk about a particular tracking mechanism, what you get isn't always idealized location tracking. You get some hints about where someone is, but they may be approximate or partial. But our technologies are getting better. And so these pictures of where people go are getting better. So imagine you have, at every second of the day, a piece of data that says where a particular human being is. Imagine it's me. So right now, you have the exact location that I'm sitting here on the stage. If you started this morning, you found me in my hotel on 77th Street. You found me walking out of there, going and getting a coffee, walking down into the subway, getting a train. You can see what time I arrived for the meeting, when I went to the bathroom, that I walked back in here. Then afterwards, you'll be able to see where I go for lunch, perhaps who I go for lunch with, if there's someone else there and you have a comprehensive set of these location records. And then you'll see me going off to the airport to catch a plane back to San Francisco this evening. Now, I said me all along, assuming that you know that this particular trace of location, you can imagine it being like a spaghetti line through space-time. Right now, it's here, but as I walk out the door, the spaghetti line kind of traces out there. You might not know that it's me. You might have a location trace for a particular human being or a particular device, but not know initially who it is. And often, in the private sector, people talk about these things being anonymous, an anonymous record of some phone or some location. But if you imagine over time what my location history looks like, it's this spaghetti line that tends to weave in particular patterns through the universe. It'll tend to go back to my house in San Francisco most nights. And it'll tend to go to my office at the Electronic Frontier Foundation most days. And so actually there's only one human being who has a location history that looks anything like that. It's mine. And so if you have an extensive location history, it's never anonymous. You can always figure out who it was fairly easily in most cases. And you can see, if you have enough of these things, as I said, not only where I go to lunch, who I go to lunch with, but also if I go to a nightclub, what kind of nightclub is it? Is it a gay nightclub or a straight nightclub or some kind of weird fetish nightclub if I happen to be into that sort of thing? You can see these kinds of very intimate facts about people. You can see who I meet up with and when. Honestly, if I was having an affair, you'd be able to see that very straightforwardly from the data. So these very sensitive facts, you can see what church I go to, what political meetings I go to. So all of the core kinds of private facts about humans that we intend, perhaps in our legal regimes, to protect, from other humans and from government are here in a single one of these location traces if it is accurate enough and it runs for long enough in time. Now, of course, sometimes location histories are not as specific. They may be just taken for a particular moment or with a device like a cell phone tower that only places me in a particular neighborhood without saying exactly where in that neighborhood I am. And so we should talk about the range of technologies that are out there that are collecting this data now and some of the ones that are beginning to exist. So imagine, first of all, that I'm not carrying any devices at all. I'm just here sitting on the stage. As Jeffrey pointed out, video cameras these days are filming me more or less all of the time in a lot of public places and private places. And increasingly, this is still a comparatively experimental technology, but it's increasingly being deployed. Those cameras are capable of face recognition. So we have video cameras that are able to, first of all, detect a face that's present and then zoom in to get a high quality picture and then extract a bunch of features and really only a small fraction of humans have my eyes and my mouth and my nose and my hair. So actually computers can do a decent job of telling people apart based on the fact that they walk past a video camera. So that data is being collected in a number of public places now. And then the clothes that I'm wearing actually may well track my location because these little objects called RFID tags are being placed in inventory, including clothing, as a way of tracking inventory. And these things have little serial numbers in them. And maybe the serial number is unique enough to identify me, maybe it isn't. But I probably, at this point, have a few of them from different items of clothing. So if someone builds the right kind of sensor and places it somewhere, they can say, hey, the same person walked past this sensor today that walked past here a week ago. So that's just before I'm carrying any devices. And then, of course, I can go out and get into a car, in which case there might be a navigation system or an accident reporting system or some other kind of electronics inside the car that's either going to continuously or sometimes report my location via satellite up into the cloud. Or even if I'm driving an old clunker and I don't have any of that fancy new stuff in there, a number of cities are talking about deploying automated license plate recognition systems. So just as I drive around a city, perhaps a little camera is going to zoom in and just read my license plate and say, oh yes, you drove through this intersection at this time. But maybe I didn't drive. Actually, I caught the subway this morning, but commonly I'll have walked down into the subway and purchased some kind of a card for the subway system. In New York, being a paranoid privacy advocate, I use cash, so probably New York can't track me, but my friends in San Francisco all have these little RFID cards that they just use every day of the year that creates a comprehensive record of when they take a train and where they took it from and to. And that's linked back to their credit card. So this is before I purchased any devices, but maybe I have a laptop and I take out my laptop and I start doing some work, and then the laptop joins a wireless network and I log into some websites. Probably that's going to create persistent records on the websites that I interact with, both deliberately and the third parties, the advertising and tracking companies that are embedded in those websites invisibly. They'll get a record of the cookies and the IP address that I'm at, and an IP address, if you know what to do with it, is effectively like a street address. So every time I open my laptop, the particular cafe or the particular apartment that I'm in, or the particular institutional building that I'm in, those things get recorded. And then, so that's my computer, and then of course we're all carrying one of these. And this thing is much more sophisticated for tracking location than any of the other stuff I've talked about. It has a GPS unit in it, much like the GPS device that was at issue in the Jones case. But it also has 2 or 3 other radio transmission devices in it. So there's a wireless network card in here. And that wireless network card is used by the operating system to get more accurate location information than GPS, because uncorrected GPS is a bit approximate. It's around the scale of a street block, so that's less sensitive at knowing exactly what room I'm in. But if you can use the wireless card in here, you get to see, there's a wireless router over there and another base station over there, and the signal strengths are comparatively 80%, 20%. So combined with Google Street View data, which they effectively publish in the form of a mapping to locations. You send a message to them saying, my phone sees 80% signal from this base station, 20% from that, and then Google says back, well, I think you're in this room or in this particular apartment in geospatial coordinates. So it has that. It also has a Bluetooth device in it, so if the Bluetooth devices are on, the phones that we carry can see each other, and so you'd get a record not only of where you were, but who else was nearby. Actually, the wireless devices as well can see each other, so if the right software is running on my phone, it will report the fact that each of you are also here in the room with me if you also have smartphones. So what we're facing is a situation where really good location data is being collected off phones. And it's going to a number of different places. It may be going to the phone company. Certainly, low resolution location data is always going to your phone company. And then it's a complicated, interesting question that I'd honestly love to know the answer to. How good is the location data that AT&T and Verizon and T-Mobile and Sprint have on each of their customers, or each percentage of their customers as a function of time? I'd love to see that data. But I think it's fair to assume that in a lot of cases they're probably collecting very good location data. We know that in some cases there's sort of remote monitoring software. There's a piece of software called Carrier IQ that was the source of a bit of a scandal late last year that in some cases reports back locations to phone companies. We know that the map service provider that you use, I use Google Maps to get here this morning. You can see the little pinpoint of me on the map. Google certainly knows that I'm here because they're sending me this map with a little blue glowing dot on it. But also probably a whole lot of other apps that we choose to install on the phone that ask for permission to show me a map for some purpose. Those also collect records. So we've got all this stuff. It includes implicitly a lot of sensitive stuff about us, and that's just about us as individuals. And there's even a tougher set of questions, which is aggregate data. At what point are we going to step in and say we need protections against someone being able to query a database of many people's locations and say, for instance, I want to see all the people who are at a particular protest, and then tell me also who amongst the people who organized that protest are having affairs right now, because that might be a useful combination of facts. And I mean, that's an extreme example, but actually, as your homework, go and think of half a dozen of these kinds of aggregate uses, and there's trouble with them. Anyway, so that's the tech perspective, and I think we'll need a regulatory regime and a legal regime to protect society against all of the unpleasant side effects that you can have if this data is used in the wrong way.
Thank you, Sharon. Let me echo what the other panelists have said, and which is it's an honor and a pleasure to be here, and I suspect that Jason will take the same position. We all have that in common, not only because of the great work that the Constitution Project does, but also the fact that all of us inherently understand that there is something very important about our private lives, our information, and what we are and what we want to be and what we do. We all inherently, innately understand that. Now, I don't know whether that's what gives rise to the modified rapture, a new expression, a new term that I wrote down here when Jeff was speaking. I guess that's similar to maybe constrained exuberance or limited glee, but whatever it is, it reflects the notion that we as human beings in what Ayn Rand described and identified as a civilized society in which privacy is the linchpin, we all understand innately that there has to be some way to protect our privacy. Now, it's been 84 years since the well-known dissent that Justice Brandeis authored in Olmsted, his very famous quote that, I paraphrase a little bit here, that they, that is the makers of the Constitution, conferred as against the government the right to be let alone, the most comprehensive of rights and the right most valued by civilized man. And now just, I guess about 15 years later, after that 1928 dissent, Ayn Rand gave additional voice to the notion that privacy is indeed the underpinning of civilization itself. It represents the freedom of man from man. The fact that we possess as free people, as individuals, the right to our ideas, the product of our intellect, the product of our labor, that is all based on the notion of privacy, not something that's communal. Even our right to a sense of justice in our society is individualized. It's not a communal decision. We have an inherent right to liberty, freedom, and justice. That's based on the right to privacy. Well, but yet here we are, 84 years from Olmsted, and 80 or 70-something years from when Ayn Rand wrote in The Fountainhead about the primacy, the fundamental privacy of privacy to civilization, and yet in many ways we have far less privacy now than we did back then, and yet by most objective measures we've made tremendous advancements in the objective measures of how civilized we are, not uniformly certainly. So I mean, why are we here? Why hasn't something been done? Certainly the Jones decision was a good decision, I suppose, from the standpoint that the Heller decision on the Second Amendment issue was a good decision back in 2008 for those of us who interpret the Second Amendment the way it was written, and that is to protect an individual right. But even that decision was, at best sort of, I guess, also modified rapture or contained exuberance in the Second Amendment arena. Why is it that these fundamental rights, these fundamental indices of civilization and liberty and freedom are so unprotected, even these days, that we have to grasp at a partial decision like Jones and say, hey, this is great. I mean, this ought to be the norm, it seems to me, if in fact privacy is a fundamental underpinning of our freedom, as reflected, I think, in our framers. I mean, I think you can clearly see, not just in the Fourth Amendment, but in the Second Amendment and the First Amendment. I mean, these are and so on. The notion of privacy, one's private religious views, one's political views are, private to that person. You own them; they are yours, and they are free from government, unwarranted government intrusion. In the same sense that our home, our papers, our effects, pursuant to the Fourth Amendment, are. And yet, this notion of privacy and the primacy, the importance of private information has received much shorter shrift than even our Second Amendment, which in many of our views has received very short shrift. But First Amendment, I mean, imagine the uproar if government said, okay, we have the right, we retain the right and the power to decide the extent of your First Amendment rights or the extent of your religious freedom rights. Yet they have no trouble at all, the government that is, saying, we're going to determine what your expectation of privacy is. We're going to determine just how far or how little your expectation of privacy leads. And yet that's really largely where we are. And the two great institutions that are supposed to give protection or give voice to those fundamental rights, the Congress and the courts, have been not totally certainly, but largely absent from this, what I think is a fundamental debate, much more important than even a lot of these other debates, because that notion of privacy underpins all of them. it underpins our First Amendment rights, our Fourth Amendment rights, our Second Amendment rights. And yet we have the government saying, well, if you choose to communicate electronically and you communicate with another person, which by definition is the essence of communication, you can't communicate with yourself, then you've lost any expectation of privacy. I mean, it's just an absurdity. It makes no sense, and yet that's largely where we are. And yet, every time, essentially, that Congress has even tiptoed into this arena, as far back as the 1980s and 2000, and we have the Leahy bill, that's still pending in the Congress. They just never seem to do anything. It becomes locked into a partisan, at some point, locked into a partisan issue, unfortunately. And yet, one of the opinions, the concurring opinions that Jeff mentioned, Justice Sotomayor, this is the justice that was pilloried by the conservatives and by the Republicans. Yet you look at her opinion, every so-called conservative, every Republican that is truly a Republican in that sense, should have been out there applauding her decision, writing editorials. Yes, this is fundamentally important, what this justice is saying. We were wrong about opposing her confirmation, at least in the sense that she has finally teed up in a way that very few justices will do, the fundamental question here. Now, she did, as Jeff mentioned, decide join the more narrower concurring opinion, because that's what judges do. But the issue is now front and center. Is this third-party doctrine that simply because you relate information or disclose information, essentially primarily electronically, to a third party, you lose any privacy? This is in a society in which every one of us is forced by the government to disclose information electronically, and then the government comes back and hits us saying, well, we forced you to disclose that information, how much money you make, where you spend that money, where you're getting treatment, where you're going to school, all sorts of information. You have to disclose that if you want to be a functioning member of our society, but we're not going to afford you any protection. I mean, you just can't win in that scenario. You're being whipsawed, electronically whipsawed by the government. And yet Congress, time and again, when there has been an effort to address this issue, is backed away from it. Part of this is because the attention span of the average member of Congress rivals that of a kindergarten student, I think. But it's also our system of governance, and I'm not critical of it. I mean, I think it's important to have congressional elections every 2 years and to have a third of the Senate up for re-election every 2 years and so forth, to have limits. But part of it also is the fact that there are so many demands. We turn to government to do so many things for us, in my view, that government has no business doing, that we force their attention into all these other areas and not really push them to make decisions in those areas that are fundamentally vital to our liberties, such as our right to privacy. I mean, how dare the government force me to disclose information to a third party and then say, by the way, you have no expectation of privacy in that. Now, it's not that government has no interest and no value, there's no value for government in obtaining, being able to access information that it needs to do its job and to enforce our laws. But that's not what we're talking about here. We're talking about striking a balance, as Senator Leahy's legislation, for example, does. Recognizing that there are legitimate needs for law enforcement to obtain that third-party information, to obtain that GPS tracking information, but not whenever it wants, and not without some very important safeguards, but building in to a new system, kind of a new paradigm, where we sort of bring the legislation into the 21st century and take it out of the hands of what was going on in 1986. I mean, heck, in 1986, there was no web. We didn't you didn't have the cloud out there. I still don't know what it is, but it's easy to throw these terms around, and Peter can tell us. But basically, very, very few people, if any, functioning members of society now that use any of this electronic technology use it only on our computer. You have to use third parties. You have to store that information. And this ridiculous notion that, well, if you open it, you've lost any expectation of privacy is absurd. How do you know what's in it if you don't open it? And then the government comes in and says, gotcha, by opening it and by leaving it in the hands of a third party, you've given up any expectation of privacy. Now, I think it's going to take some real work on the part of the American people. If we care about this issue of privacy, then we're going to have to do something about it. We're going to have to push Congress consistently over a period of time to address this issue. We're going to have to support those organizations, some of those represented here, that address these issues in our legal system, whether they are the American Conservative Union or the ACLU or the Constitution Project or EFF or EPIC, all sorts of good organizations out there. That get away from party labels, which seems to constantly doom these issues to being tamped down rather than fully addressed. It really is going to take some hard work on the part of the American people, but it needs to be done. ECPA is woefully out of date. It needs to be updated, and we need to also get away from this notion that we allow Congress over and over again to say, well, okay, we'll address this. We'll pass something that purports to address, and then we'll move on to something else. It's going to take more than one bite at the apple because technology is constantly changing, and that's why this program today, and I'm sure the work that you all do, even when you're not here listening to us on these issues, is so very important. And it needs to be a sustained effort to get these issues before the courts and to get these issues before the Congress over and over and over again, and not let them refocus their attention constantly on something else. So, Sharon, I appreciate very much being here today, and I've learned a lot, even beyond modified rapture from the program so far, and I'm sure I'll learn something from Jason.
Thank you, Congressman. I also appreciate the opportunity to be here, and I want to speak to you from a little bit different perspective. I'm going to talk to you as both a citizen and a prosecutor, because I have both in that order. And as a citizen and as a prosecutor, I agree completely with Congressman Barr that privacy is, as he put it, the fundamental underpinning of our freedom. Actually, I have 3 kids under the age of 7 at home, so I have no privacy in my own house, so I appreciate privacy in a way that I never did before. And I think that, as Congressman Barr alluded to, it takes all 3 branches of government acting appropriately in a system of checks and balances to ultimately make sure that our privacy is protected. We need Congress to set the rules of the road for law enforcement to follow and providers to follow. We need prosecutors and law enforcement officers to follow those rules, and we need the courts to make sure those rules are being followed properly, and as in the Jones case, to sometimes clarify those rules where they need to be clarified. The Jones case has obviously sparked a great deal of discussion prior to today, and including today, about location privacy. And I want to talk about that issue, and in particular some of the proposals that the Digital Due Process Coalition has put forward about location privacy. But I think I'm going to have to do that during the discussion portion, because what I'd like to do first, with the limited time I have at the outset, is to talk about Jones in the context of the larger debate about reforming ECPA. ECPA, as Sharon alluded to, is the statute that sets the rules for law enforcement access to stored content and non-content information about your electronic communications. And it also sets the rules, or I would suggest the lack of rules, for your providers like Google and Yahoo and Facebook to share information about you, including your location information, with other companies for their own purposes. Now, the statute was passed in 1986, but I would respectfully disagree that it's woefully out of date. It's been modified a number of times in the last 20 years, including major overhauls in '94 and 2001, and the most recent amendments were just 3 years ago. But we are once again at a point in time because 3 years when it comes to technology is an eternity. So we are once again at a point in time when we have to assess whether amendments to ECPA are necessary to keep pace with changes in technology. And one thing that I do agree with in Justice Alito's concurrence is his observation that a legislative body is best situated to, as he put it, to draw detailed lines and to balance privacy and public safety in a comprehensive way. That's what ECPA has done for 20 years, and that's what it needs to continue to do, perhaps in a somewhat amended form. And the national discussion about the future of ECPA and about the kind of lines that have to be drawn between privacy and public safety and innovation and the economy is critically important for all of you and for all Americans, even people who have never heard of ECPA prior to today. It's actually a pretty important statute in your lives, even if it's not one that you're intimately familiar with. So let me just address a couple of myths about government surveillance and raise a couple of big picture issues that I think should be central to any discussion that we have together about technology and privacy. First, when law enforcement seeks access to electronic communications or location information or other records of suspects, it's for the purpose of solving crimes, and it's for the purpose of catching criminals, including criminals who actually are committing crimes that threaten your privacy. Cybercrime and similar threats to your privacy and to all of our cybersecurity generally are growing. Every day, if you read the newspaper, you see more and more reports about large-scale thefts of data, credit card numbers, bank account information, people having their identity stolen, people having their credit cards stolen, people having their bank accounts raided. And the attacks are more and more sophisticated. We're announcing today here in New York a major takedown of a group of global hackers that was announced, became public sometime between the time Jeff finished talking and the time Peter started talking. And you'll hear about it on the news when you leave here. But even though those are major hackers whose charges were announced today, there are many, many more like them. And cyber criminals everywhere in the world can, from the privacy of an apartment in Romania or Russia or China, launch an attack that affects somebody here in an American town or American city. And as the use of mobile devices continues to grow in the ways that Peter described, those devices are increasingly tempting targets for identity thieves and other criminals. As we all know, smartphones and tablets are in a very real sense mobile computers. And as the line between your mobile device and your personal computer is shrinking, your mobile device becomes yet another computing platform for cyber criminals to use to attack and to put malware on and to infect. In the old days, last year, 2 years ago, the typical way that a criminal will try to get malware on your computer is, one way would be to send an email and have it be embedded as an attachment to an email. Nowadays, when people are using smartphones, it's not uncommon for people to try to put malware into an Android app. So when you download an app thinking that it's going to be a game for you to play or some useful function on your phone, you're actually installing malware in your own computer and infecting your own computer, and that becomes another platform for a cyber criminal to either make you part of a botnet or to launch an attack against your personal privacy. And law enforcement, to catch the people who are doing all those terrible things, we have to work in unraveling the chain of providers and go from provider to provider trying to track those criminals. And oftentimes that is a long exercise, and it's an exercise that takes us all the way around the world, because those criminals, as I said, could be sitting in the next room, or they could be sitting in a room in Eastern Europe. And the ways that those criminals use to hide their tracks through encryption or proxy servers or anonymous email accounts makes unraveling that chain extremely difficult. And so that's the purpose for which law enforcement is seeking that information. But it's not just to solve cyber crimes. It's not just to solve crimes against your identities. Electronic evidence in this day and age is needed to investigate and prosecute literally every type of crime you can imagine, from drugs to gangs to violent crime to white-collar offenses, even to terrorism. I spent most of my career prosecuting violent crimes, gangs and contract killings and other murders. And in this day and age, you need electronic evidence to be able to solve every one of those crimes and to prevent, in many cases, those crimes from happening. You need that evidence to prosecute a gang leader who is using an email or text messages or instant messaging to issue directives to one of his underlings to commit a murder. You need that information to protect a high school student from cyber stalking. You need that evidence to rescue a child that's being sexually abused by her father and being victimized again with the images that abuse are posted online. You need that evidence to rescue a kidnapped child and to catch the kidnapper. All of those things are not hypotheticals. Those things happen every single day. And increasingly, cell site information and IP addresses and the kind of information that we can get from providers about the way criminals are using computers are increasingly necessary to solve real-world crimes, not just cyber crimes. I often say that electronic evidence and the process that we have to go through under ECPA to obtain it is like oxygen, because prosecutors can't live without it, and they rely on it in nearly every case every day. There's a myth out there that law enforcement wakes up every day like jackbooted thugs trying to figure out ways to vacuum up as much personal information about Americans as we can. And the truth is, what motivates law enforcement officers every day is a desire to protect Americans' privacy by investigating and prosecuting the criminals who threaten it, and protecting the public by using electronic evidence and other types of evidence to prosecute real-world criminals. So that's sort of myth number one. Number two, I want to make sure that everybody understands that to get electronic evidence, law enforcement is required to use lawful process. There is a myth out there that the government can read whatever emails it wants, get whatever information about you it wants online whenever it wants, and that's just not the case. The issue is not whether law enforcement can get your information without process. The issue is what type of process is required and what level of evidentiary burden the government has to overcome in order to get that information. The courts and ECPA and other statutes have recognized that there's a spectrum of privacy interests that the laws recognize, and the level of authorization that the government needs, whether it's a grand jury subpoena or what we call a 2703D order, which is a form of court order that I can talk about later, or a search warrant, depends on the nature of the information being sought. You sometimes hear the government can get your email without a warrant, or that it's warrantless. But no one should think that warrantless means a blank check. Warrantless simply means that there is some other lesser form of process that the government has to go through to get the information, and that the showing the government has to make is something less than probable cause. The current ECPA debate, bless you, is really about whether the statute continues to strike the right balance between privacy and public safety and the need to foster innovation and economic development. And those are difficult lines to draw, as Justice Alito's concurrence reflects. And that's because those are complicated questions. But in doing so, it's important to understand that law enforcement doesn't typically start out having probable cause. That is, having enough information to get a search warrant. Every day in this country, there are agents and prosecutors who are using these less intrusive techniques that you can get through lower levels of process as building blocks to develop probable cause for the use of more intrusive techniques like wiretaps. If the standard is raised for electronic evidence, whether you're talking about location information or other types of evidence, to a flat standard of probable cause, that is above the already high standard that we have to meet to use less intrusive techniques, that effectively means that we're drastically compromising the ability of law enforcement to investigate and prosecute the kind of crimes that I've mentioned. If we have time, we can go through many, many examples of real-world crimes where law enforcement would not have been able, in a probable cause-only world, to have solved the crime, or to rescue kidnapped children, or to have successfully prosecuted murder, because we needed less intrusive techniques using lower levels of proof in order to build up the probable cause to get to use more intrusive techniques. So as we discuss amendments to ECPA, what's critically important from a law enforcement point of view is that we not compromise public safety, that we continue to draw the lines in a careful way, but draw them in a way that doesn't hinder the government's ability to effectively and efficiently enforce the criminal laws. The Jones case essentially has highlighted an area where we now need a search warrant in situations in which it wasn't previously obvious to everybody that one was required. For what it's worth, I was prosecutor for 12 years before I became a Main Justice bureaucrat, and I always taught my prosecutors, and in my own cases, to use a warrant even when you don't think you need one. There's a couple reasons for that. One is you sometimes have to actually get on someone's private property to get access to their car, but the more important reason is that even when you put a tracker on, if you don't have a search warrant, you can only monitor the vehicle in public spaces. And it's not uncommon, for example, in a drug case, for the drug dealer to drive his car into a private garage, do the exchange of drugs or money in a private garage, and then to drive out. And if you don't have a warrant, and the person's in a space that's constitutionally protected, without a warrant, you can't monitor that. So I always taught people to get a warrant. I think that in this case, it's important to note that the government did get a warrant. It turns out, for the reasons Jeff alluded to, it was not valid when executed, but they weren't cowboys. I mean, they tried to get a warrant, and for technical reasons, it became an invalid warrant. But the best practice is now essentially going to become the required practice. That is, you get a warrant in every one of those situations. The third big general point I wanted to make, and then I'll stop and we'll open up the discussion, is that privacy doesn't just mean safe from law enforcement. Any honest and complete discussion of privacy has to include a discussion about the ways that providers use your personal information, and this was alluded to in Peter's remarks. As I said before, when law enforcement seeks your information, we have to use lawful process to get it. We have to make a certain evidentiary showing to get it, and we're using it to solve crimes. And that's part of our core mission. And law enforcement requests affect a relatively small number of computer users. For example, for Google, just users of Google, in the first 6 months of 2011, the total number of requests to Google for user account information, that's state and federal law enforcement combined, was for accounts of about 11,000 users. That's 0.03% of all the Google users. So it's a very, very small percentage of online accounts that are the subject of law enforcement inquiries. But every user of the internet, every 100% of the people using Google or of a mobile device should think more about how their personal information and their location information is being used by their providers. Under ECPA, there are significant restrictions on law enforcement's ability to get information. We have to use process, as I said, and if the provider wants to give the information voluntarily, there are very limited circumstances in which the provider can do that. But ECPA provides no constraints whatsoever on the provider's ability to share that information with other companies for marketing purposes or for other commercial purposes. And you should contrast that with two other statutes that are even more obscure than ECPA. One is called the Communications Act, which governs access to information about your telephone use. The other is called the Cable Act, which protects the privacy of your information about what you're watching on TV. Both of those statutes place much greater restrictions, by definition greater restrictions, since ECPA places none. But they both place significant restrictions on your cable company and your phone company's ability to share with other companies information about what you're watching on TV and who you're talking to on your phone. But ECPA, which governs all of your online activity, provides no restriction whatsoever on your provider's ability to share that information for their own purposes. It's not an accident that you get ads on your phone for stuff that is specific to you, that for a Starbucks around the corner from where you are. It's because your location information is being shared for advertising and marketing purposes. You may recall last May there was a big controversy when it became known that Apple and Google were collecting more location information than people realized, and there was a Senate Judiciary Committee hearing on that issue, and I had the opportunity to testify there. And one of the things I took away from that experience is how really woefully underinformed consumers are about not just the way the location information is being collected and used, but about other information as well. And it's not consumers' fault. I mean, one of the things that the White House announced a couple of weeks ago, the call for a Consumer Privacy Bill of Rights, and one of the principles of that Bill of Rights, when it's adopted ultimately, is transparency and a requirement that providers be clear with all of us as customers about what it is they're collecting and how it is they're using that information. And it's something that we all have to be vigilant about as well. You are at much greater risk as you walk around the earth today of a pervasive invasion of privacy in the form of how your providers are using information without your knowledge or full understanding than any of you are about some invasion of privacy by law enforcement. Lastly, I think it's worth noting that sometimes privacy versus public safety can be a false dichotomy. It doesn't protect your privacy if hackers and identity thieves and other criminals who steal personal information can get that information and raid your bank accounts and charge your credit cards, while law enforcement can't get the data it needs to catch those people. Truly protecting privacy requires not only that we keep personal information from the criminals who seek to steal it, but also that we ensure that law enforcement can get the information it needs using appropriate legal process to catch and disable those criminals. So those are sort of three basic principles, or there may have actually been closer to 5 basic principles that I wanted to articulate. And then I'm happy to discuss during our discussion the different forms of location information and why they shouldn't be treated with one brush.
Thank you all. I do want to give time for all of you to ask questions, but just before I do open up the floor, I just very quickly want to hone in a little bit with a quick question to each of the panelists on some of the conversation we've had so far on what's coming next, and particularly the third-party doctrine. So the majority opinion in Jones, as you've heard, focused very narrowly on this question of trespass and only explicitly covers when the police themselves put the device on vehicle. So in terms of if the device was already there, or if they want to get that information from law enforcement wants to get access from a third party, what the implications are. So I just want to have slightly targeted questions for each of the panelists. We'll try and go through that quickly so we can have some time for your questions. So first, to Jeff, you talked a little bit about in the reasonable expectation of privacy context, the line between what's short enough surveillance or what's longer was left open. But if you look toward the third-party doctrine and what type of developments you may see, if the courts were to move to sort of narrow Miller type analysis, but say, as Sotomayor points out, most people don't think when we turn over information to a third party, as we have to do so often in daily life, that we're turning it over for all purposes everywhere. Do you see any kind of way to sort of cabin the third-party doctrine in the court's analysis coming forward?
Yes, the crucial question is how to cabin it. And even Sotomayor wanted to retain this idea that people's subjective expectations of privacy matter. What do we actually expect when we turn over information to third parties? That doesn't seem secure enough to me, because simply by announcing a privacy policy, our cell phone companies could say, you realize when you pick up the phone, you're revealing your locational data to us, and we may reveal it to the government, and that would then defeat all of our constitutional protections. So I hope, in a case, whether it's this case, U.S. v. Earls from the New Jersey Supreme Court, or I'm really hopeful that the Ninth Circuit, which has proved to have on it the Louis Brandeis of the digital age, namely my hero, Judge Alex Kaczynski, the Chief Judge of the Ninth Circuit, has written a series of more path-breaking and creative opinions about how to protect privacy, I think, than any other lower court judge. And it was Kaczynski who came up with the best concurrence in the Jones case, where he said, my parents were born in Bucharest, they were Holocaust survivors, they couldn't have imagined the arrival of George Orwell that takes place when we are deemed to have no expectation of privacy and information we've turned over to third parties. So if Kaczynski gets the cell phone case, I hope he'll take that opportunity to say, just to throw out the whole thing, to challenge the idea that when I reveal information for one purpose, I abandon expectation of privacy for it, in it for all purposes, regardless of whether or not I'm informed about that and expect it. And obviously they don't need to throw out the whole thing in terms of re-examining the many areas of doctrine that are controlled by it, but at least within the cell phone context, they could say that when law enforcement seeks access to data that can reveal a great deal of personal and intimate information about us, they can't rely on the notion that we've abandoned expectation of privacy in it, something like that. I'd be interested in Jason and others' alternative formulations about the best way to do it. So Sotomayor didn't really offer a model. I hope Kaczynski will, but that's my tentative thought, and I wonder what my colleagues think.
We'll get there. We move down. Okay. Next to Peter, I was trying to, in listening to all of the various tracking technologies you outlined, as best I could tell, most of those are ones that if law enforcement wanted to take advantage of, if not all of them, it sounded to me that third-party doctrine would have to change, or there would be, at least from the analysis we're talking about here with the Fourth Amendment and what the government can do, no barriers. Is that correct? Pretty much all the
That's
technologies
right.
you outlined?
I talked primarily about technologies where there is some service provider or company, perhaps not all of them. In some instances, I think we'll see governments running the video cameras that read your license plates, or the surveillance cameras on streets that recognize your faces. But in a lot of other cases, if we're talking about a phone, it's a Google or a T-Mobile or an AT&T, some other third party that is going to be the handmaiden for the data being passed around. Now, I think we've entered, if you talk about the expectation of privacy, I think we've entered the realm of paradox, where on one hand, I don't think anyone expects that as a condition of living in the 21st century, they have surrendered their right to privacy with respect to their religious beliefs, or their political beliefs, or their sexuality, or their business dealings. And yet, we are totally addicted to all of the services that are convenient and useful that we get from our phones and all of these other devices. And so, I think we need to resolve the paradox through policy or law in a way that gives us both the convenient services and the privacy that we expect.
Congressman Barr, I'm going to ask you, you talked about being disappointed in the courts and that you can only expect, half a loaf now coming out of the court decision, but still working so hard to get Congress to amend laws like the Electronic Communications Privacy Act. So with regard to the third-party document we've been talking about, whether law enforcement can just obtain something because you turned it over to a third party, where do you see the greater likelihood of success for those seeking to extend those safeguards? The courts or Congress?
Well, I'd like to say the Congress, because that's the body that should be making these decisions, and then, pursuant to the old doctrine of Marbury v. Madison, the court, decides ultimately if they've gotten it right. But in order to decide if they've gotten it right, Congress has to do something. And right now, they seem to be completely locked down in partisanship. So I'm not terribly optimistic. I'm not sure if Senator Leahy's bill has any co-sponsors. It's a good piece of legislation. Is it perfect? I seriously doubt that. But it's Congress needs to do something. But right now, I'm not terribly optimistic. And I know, as Jason mentioned, the administration has taken some steps in the area of addressing some of these issues. But this is ultimately, it's not a problem with law enforcement. It's not a problem with the Department of Justice. It's not a problem with the courts. It's a problem that the American people have. We as a people need to decide if we want to do something about this or not. Jason is absolutely correct. A lot of it has to do with privacy that we already surrender sort of unthinkingly to commercial interests, to businesses and so forth. That's true. There is an important difference. The government, when it gains access to that information, can put you in jail. The corporation cannot. So that is an important distinction. But addressing the problem goes far beyond simply placing limits on government. We need to decide if we as a people truly value our privacy. We have to wake up to that, and to some extent that's happening. But I'm not terribly optimistic, certainly with the current configuration of Congress, to be honest with you.
Finally, Jason Weinstein, you emphasized a lot that it's not a question of the government just grabbing up all of information. It's a question of what standards they should follow, and I think that's a point well worth emphasizing from the Constitution Project's perspective as well. Location tracking information is not something we want to say, oh, the government can't have that. We just want to make sure that law enforcement is complying with the proper safeguards that should be in place, so they're actually going after the bad guys rather than innocent Americans. So I share that view. I actually want to let you or let Jeff ask you the question of looking toward in the context where we don't have Congress drawing lines and saying, okay, in D order we have this standard and making more nuanced lines. If you're looking toward the courts and the third-party doctrine, do you have any thoughts on where those lines might be appropriately drawn?
Yes, let me sort of address it this way. First, I think we're still evaluating the opinion and the implications it may or may not have for other law enforcement techniques. But I can talk about cell phones because I think, as Jeff said, that's probably the next frontier of the battle. And I think to understand where the law might go, it's probably helpful to understand what we actually do now. If we want to get GPS information, precision location information from your cell phone, we get a warrant. Let me say that again because that may be a surprise to you. When we get GPS information from your cell phone, we get a search warrant based on probable cause. If we want to get less precise information, cell tower information, which is far less precise, and which is not the kind of continuous pervasive surveillance that the concurring justices were concerned about, but is sporadic and is general and is imprecise and is only delivered during times when you're using the phone. If it's historical, that is, if it's general information about what general location you were in 3 weeks ago, we get what's called D order, and I'm going to talk about that in a moment. If it's perspective, if I want to get it for, I want to know what cell towers your phone's hitting off tomorrow. In some districts in the country, I can use a D order, and in some districts, a search warrant is required based on probable cause. I practice in a district that in 2005 switched from one to the other, and our ability to get prospective cell tower information almost disappeared. But I made a list this morning of all the different ways in which third-party doctrine might impact you on your path to come here this morning, and it would have been longer, but the hotel is ridiculously small, stationary. Let's say you made a phone call from a landline at your house. Using your phone records, which I can get by subpoena, I can find out that you were in your house at a given time this morning. If you drove over a bridge that had EasyPass kept a record of your travels. If you parked at a parking lot that has a surveillance camera, there's a picture of you parking this morning. If you went into an office building, I don't know if you had to sign a visitor log when you came in here, but if you did, there's a record that you were here at a given time. If you went to an ATM machine, you've got a paper record and a video record of your presence at that ATM machine. It's that location at that time. If you went to Starbucks and paid with your credit card, with appropriate process, we could find out that you were at Starbucks at a given time. And if you said it happens in Federal Express, there's a record that you were in the Federal Express. All of those things are records of third parties, not electronic communications, but the records of third parties that the government can get with subpoena. Other than the phone records of your landline, use of your landline at home, I can't get any of those with a subpoena when it comes to electronic records. Everything I just listed, I can get with a subpoena. What you do with your electronic devices, except for your landline phone, I can't get any of those with a subpoena. I have to use a D order. And the standard for a D order is that I have to satisfy a judge that there are specific and articulable facts providing reasonable grounds to believe that the information I'm going to get from the provider is relevant and material to a criminal investigation. Now that's not probable cause, it's probably best approximated as reasonable suspicion. But in 1994, when ECPA was amended in 94 and the standard for a D order was raised to specific and articulable facts, it was hailed as a significant privacy advance that conferred a high degree of protection and would prevent law enforcement fishing expeditions. And the person who said that was Jerry Berman, who at the time was the executive director of BFF. Now, that same standard is sometimes derided as a rubber stamp, but it's just not the case. Judges are vigilant in enforcing the standard of a D order. Prosecutors are repeat customers in front of judges, and their reputations matter to them, and their credibility is on the line every time they appear in front of a judge and assert that they've got enough evidence to meet the standard. And anyone who thinks that a D order standard is not a meaningful standard has never tried to get one signed in the District of Maryland. I can't count the number of times I've had D orders given back to me by a magistrate who said that I didn't have enough evidence to satisfy her or him that I'd met the standard. The D order standard, Jerry Berman was right, BFF was right in 1994. The D order standard does confer a meaningful level of protection. It's not probable cause, but it's not far from probable cause, and judges are vigilant in enforcing that standard. But I wanted to give you that list because I thought it might be interesting for you to know the volume of third-party records that don't involve the use of your cell phone that we can get with a subpoena, and the fact that I can't get any of those records with a subpoena, that the law already protects that kind of information from third parties related to your cell phone use more than it does any other aspect of your lives. Does it protect it enough? Well, that's a debate that we can have. Whether it should be probable cause, whether it should remain specific and articulable facts. I'll stun you to know that I think the latter is the case. But that's the debate that's going on now. Senator Leahy's bill proposes probable cause for all. I think for a lot of reasons that draws the line in the wrong place and significantly compromises public safety. But we're eager to work with him and the others who care about this issue on the Hill and other interest groups as well to try to come up with a way legislatively to draw that line. If not in the exact place it is now, then a place that's not far from it. I think that in terms of the courts, and then I'll stop. One dicta from one justice does not, the judicial trend make. Although I think that I'm encouraged that there were 8 other justices who didn't join in that observation by Justice Sotomayor, because I think that it's, with due respect to her, I think that it's that the third-party doctrine is alive and well and should remain so.
Thank you. Okay, I do want to give a chance for anyone who wants to ask a question. I see we have a microphone in the aisle, if you can make your way over there. And if you would, please identify yourself before, and please also do actually ask a question.
Well, hi, I'm Chris Stone at the Harvard Kennedy School Criminal Justice Program and soon to be at the Open Society Foundations. I convene a meeting of police chiefs around the United States to talk about the future of policing every 6 months, and the subject of privacy and technologies that have come up today come up a lot. The examples, the head of the National Police Improvement Agency in the UK already has the number plate technology, and it's useful. I just want to give a couple of examples that didn't quite come up in the panel. They look for patterns, so they're not investigating a crime. They take huge amounts of data, basically where every car in the country goes, and they look for interesting patterns in the anonymous data, and when they find some, they start investigating whether that's criminal activity. So it's actually starting with the data and moving to to the suspect and to the crime, not even starting with the crime. And that use of pattern recognition in this data, I think, is a growing trend. If Bill Bratton's hopes for predictive policing come true, it's going to be a key for a lot of law enforcement activity. And I think understanding the uses beyond trying to prosecute an individual of these data are hugely important. The second example is from murder scene witnesses. A lot of what we're talking about is court protection of somebody who's been prosecuted based on this information. But if there's a murder and you want to find out who was standing nearby, and you can use cell phone information to do that, and then you can go visit those witnesses, you're not looking to prosecute them. And so the normal checks of a Fourth Amendment challenge to that won't come up. It's not clear how that case would ever get to court, and it's not clear whether police, what controls the police use of that information. But the last example comes from two police chiefs who have started, when they do a search incident to arrest, and someone is carrying a smartphone, use it as an opportunity to get all their contact information, and by linking different contact information of different purported gang members, begins to trace and put together a picture of a social network of what they imagine to be criminal gangs, all using data obtained through the Fourth Amendment permission of a search incident to arrest. Those three examples are just the tip of the way that the technology, I mean, someone said, 3 years, I think it was Jason said 3 years is an eternity. 3 minutes is becoming an eternity here. And the question I wanted to ask is whether we're focused on the wrong part of the government. The debate so far has been about whether the courts or the legislature is where the rules need to be made. And I want to ask whether it would make actually whether we're going to need police agencies across the country to adopt chief privacy officers, so that in fact the rules are being made the only place we can keep up with the opportunities available to law enforcement to do this. If there isn't a voice inside police agencies that is allowed to speak up for privacy concerns and try to stop the experimentation until the courts stop you or until the legislature stops you, we won't stop it. And at least as one police chief suggested, today our obligation is to do everything we're legally allowed to do to find that criminal. And we wait for the courts or the legislatures to say, I can't use this piece of information. Until then, I must use it if I'm trying to solve a crime. We have to end, and he suggested, we have to change that habit. We have to build the brake into the police agency, or the technology will always let us get around whatever the last protection was. I'm curious if you think we can look to police agencies to start protecting our privacy.
Okay, I'm going to give my panelists a chance to answer that. I just want to, first of all, though, flag for you, with regard to your first example, that touches on something needs to include data mining, which is done by not only police, but all sorts of agencies. And I just have to mention, this is another issue that the Constitution Project's Liberty and Security Committee has looked at, and I'd be happy to share with you. We have a report making recommendations, and often we are asking the executive branch agencies to do this themselves. It's not necessarily the courts or the legislature that can't get the rules. I think that's an important point, but I'm sure panelists would like to weigh in as well on the broader ones.
It's a fascinating suggestion, and it would certainly be helpful if police officers could have privacy officers who would, in addition to congressional and judicial constraints, evaluate technologies, require the least intrusive means, and so forth. I'm not optimistic with the way that privacy officers have been performing in other arenas. I was very disappointed to see the Department of Homeland Security Privacy Office, for example, approve naked body scanners at airports, even though there was a much less intrusive alternative, namely the blob machine that they've been presented with and could have required. It took a political protest, the Don't Touch My Junk guide, to make them go back to the drawing board and adopt the blob machine thing retrospectively. So in practice, I wonder how it would work, and I also wonder what statutes or standards they would be applying. But it seems like well be worth thinking of in addition to all these other things. I love all three of your examples because they show just how inadequate the current doctrine is to think about each of the issues. Just to take one of the three, the idea of using search incident to arrest to search smartphones is indeed a real problem. You might well say that if a smartphone is just like the private diaries that the framers of the Constitution gave the highest protection to, you shouldn't be able to look at the whole thing if you search someone, if you arrest someone for a low-level crime, or even at the border, computer searches and smartphone searches. So these are all areas where, I mean, you know, a privacy officer that was required to adopt the least intrusive technology with minimization procedures and not share data except if it related to serious crimes. I mean, you could imagine in theory, but I fear that in practice, you're going to need congressional and judicial constraints as well. It's very interesting.
Like Jeff, I think it's a very intriguing suggestion. The political realities are that, in my view, working with a lot of police chiefs around the country, they're not going to really do very much. Police chiefs are, by and large, appointed by the local political entity, city, county, whatever. So I think in order to make your idea work, and I'd like to see it happen, there needs to be some teeth. And that can either be primarily state legislation, local ordinances, but I really think it's something that states need to address and mandate, as opposed to what frequently takes place, an entity or a law enforcement agency, or sometimes even federal agencies, as Jeff mentioned. They'll make a big deal about having a privacy officer, but there's no teeth there. There's no power behind the fig leaf. So I think that's where the rubber really hits the road in many respects, is with local law enforcement. And by and large, these are very dedicated men and women who have a lot of integrity, but they're controlled largely by the local political entity, and unless they are forced to actually do something about privacy and held accountable for it, it may wind up being worse than not having those officers, because then people think that their privacy is being protected, but it's not.
Every police officer in the country has a privacy officer, and that is the prosecutor. The fact is, in Baltimore, we did a training program where we trained literally every line cop for 1 week every year. They had to go through the same training every year. And a lot of the issues were on, where the Fourth Amendment lines are, where the Fifth Amendment lines are, what you can and cannot do under the law as Congress and the courts have defined it. But on a daily basis, the prosecutor acts as a privacy officer, because the teeth, as Congressman Barr said, you need teeth to make anything enforceable, but the ultimate enforceability of the guidance from the prosecutor is the prosecutor isn't going to take the case. If you violate the Constitution, or if you obtain the evidence in a way the prosecutor believes is illegal or is going to be suppressed, the prosecutor won't take the case. And police arrest people not for fun, but because they want to see them go to jail and get convicted. And I think that prosecutors perform that function every day. Our goal is to protect the public and enforce the laws, but to do so in a way that respects privacy and then stays within the boundaries that the courts and Congress have defined.
Hi there, I'm Julia Angwin. I'm a reporter at the Wall Street Journal. Question for Mr. Weinstein about the perspective tracking. You mentioned that there were two standards. Basically, in some districts they choose search warrants, some districts D-orders. I'm wondering if you can talk a little more expansively about that, because it seems like that might argue for a national standard if nothing else on this panel has.
Well, the department's view is that there should be one standard. It should not matter whether you're in Portland, Oregon, or Portland, Maine, what standard applies when the government wants to get prospective cell tower records. The question is what that standard should be. It's our view that the D-order standard, which was uniform prior to a bunch of courts deciding that it should be elevated to probable cause, the D-order standard is the correct standard, but we're eager to work with Congress to discuss that issue further. But I think everybody involved agrees that it's not good for the public, it's not good for law enforcement, it's not good generally to have two different legal standards applied to parts of the country.
So what determines the difference? Like some districts just decide to go higher?
There are others who know the history of it better than me, and I can put you in touch with people who were sort of there at the inception, at least who had a national perspective when it started happening. And I'm not sure what ground zero is, what district it was, but there was around 2005, a couple of opinions started to come out from magistrates holding that the statutory authority it's a combination of two different statutes. We call them hybrid orders. It's a combination of the Pen Register Act, the Pen Trap Statute, and 2703D that provide the combined legal authority for historical cell tower records. And there were some judges who found, as a matter of statutory interpretation, not necessarily constitutional interpretation, but just statutory, that those two statutes together combined didn't give adequately clear statutory authority for prospective cell tower records. And that caught fire in a number of districts. And now, I don't know what the percentage is, but it's roughly 50-50, where about half the districts in the country, maybe a little more than half, the judges have adopted the probable cause view, and the other percentage use the due order standard. But even those that have adopted probable cause as standard have done so, at least the opinions I've read, based on the grounds that the statute just doesn't clearly provide that authority. And so they're almost calling out for Congress to clarify that legislatively.
Hi, I'm Allie Bohm with the ACLU, and I thought your discussion of the standards is really, really interesting. We recently filed coordinated public records requests with 382 law enforcement agencies across the country, seeking information about what sort of standards they're using to track cell phone location. And we've gotten about 187 responses back, and they really run the gamut. So some of them are doing what you're saying, and some of them are like, oh, we don't get anything. We do whatever the cell phone company tells us to do. And I'm sort of interested about what guidance is getting down to sort of the, podunk police departments in the middle of nowhere about these standards, because at least the documents they provided to us say that they're not all following that.
Well, I'd be curious to see the documents and to talk about it more offline. I mean, the statute, the standards that I laid out are the law of the land, and should be applied that way. They're certainly in the federal system applied uniformly. So I'd be curious to see the data, because it's surprising to me to hear that there'd be that kind of disparity.
Sure. So and I'm happy to give you my card or take your card afterwards, and I'll send you more information. But we should be coming out with that shortly, and aclu.org/location tracking will eventually have every single one of the documents on it.
Next.
I'm Jack McKenzie. I'm a recovering journalist, but I still do a little bit of information gathering as a consumer. And I time and time again, when you take it out on law enforcement, I think of Google. I don't know why I think of Google all the time. They probably know that I'm thinking about them.
They're probably thinking about you too.
But this is a lazy question. Would somebody please use Google in a sentence, and in particular the guidelines and the cross-platform stuff that they're putting out? I say it's lazy because I just haven't done the work. You know what I mean?
I mean, this is a very broad question. Use Google in a sentence is the question I'm taking.
Well, the adequacy of their privacy assurances from this floating of these principles that they've done on the web.
I would say that the model for Google is they're a company that wants to have all of our data. They also aspire to making themselves be trusted with all of our data. So in some ways, I would say they try harder than most of their competitors to resist, for instance, the fact that they publish data on which governments ask them for data and how often they turn it over is unusual, and you don't see other global corporations that are in similar positions publishing the same kinds of data. And so I think Google is trying to be the most trustworthy place for you to store all of your data, basically to be your priest. They want to know what you're thinking and to have all of this stuff about you and to be somewhat trustworthy with it. But there's a bound on that because the law can say actually you have to turn particular things over. And it might not be just US law, of course, it's the law of hundreds of countries. And so we have a structural risk because we choose to use that company's services. We also have the same structural risk, maybe a worse structural risk from dozens of other companies that don't get as much attention as they do.
Well, would you say you trust Google?
To do certain things, and there are other things that it's beyond their ability to be trustworthy with respect to. If Google gets a lawful request from the German government to turn over some data, I have to trust them to comply with that.
I'm Jenny Sloan with the Constitution Project, and I want to follow up on what Chris Stone described, which are some situations that I hadn't really thought about and are kind of scary. In other areas that the Constitution Project has worked in, we have tried very hard to get Congress to put restrictions on local political entities by withholding money, burn grants or whatever, unless they comply with certain standards that Congress has set forth. And I'm wondering if if privacy people in police departments are really not that effective, and there may be police departments that are quite scrupulous about protecting privacy, but there are a lot of very small departments around the country, as my colleague from the ACLU described, that have no clue about any of these issues. And I'm wondering if there's just some way to either punish them or at least alert them that there will be consequences if they don't follow whatever laws Congress prescribes. That raises the other issue, of course, of whether Congress would ever prescribe anything. But what about the idea of using financial incentives to force privacy concerns on the police and the prosecutors?
I mean, we all know that the Supreme Court, the courts of the land have long held that it's an appropriate exercise of federal authority to take money and then give it back and attach all sorts of strings to it, and that can work from time to time. But going back to my earlier point, I really think that it is the responsibility as much of state governments to start addressing these issues as it is for the federal government. Certainly we need, as Jason indicated, and in a lot of areas, including those relating to perhaps commercial entities and what they can do with the information, we do need some national standards, because similar to discussions of Second Amendment, for example, we're dealing here with, in my view, fundamental privileges or immunities. And that should not be subject to the whims of a particular jurisdiction. But by the same token, I try and be a firm and try and be a consistent respecter of principles of federalism. And there really is, I think, an important role for state legislatures here. Unfortunately, to some extent, they fall victim to the same problem that we have in Washington, the extreme partisanship that seems to permeate the country. But I'd much rather see states address these issues and start setting appropriate standards rather than try and get involved with the federal government withholding money. I mean, there's nothing wrong with that, other than the fact that, in my view, the government is taking too much money and giving too much back and controlling too much to begin with. But it certainly is it can be, if used properly and consistently, an effective means. But I'd much rather see the state legislatures start tackling this problem and making sure that those police departments and the sheriffs that are within the jurisdiction of the state laws pay closer attention to and start adhering to appropriate standards.
Hi, my name is Chris. I'm a third-year student at New York Law School, and I'm actually arguing this case in a moot court competition in 2 weeks. I have two questions. Thank you. I have two questions, if you'll indulge me. The first is sort of separation of powers issue. I kept seeing this recurring in my opponent's brief, that the issues that arose in this case are the exclusive providence of Congress. And I guess, as Congressman Barr noted, Congress has not acted on these issues, and neither have 49 of the 50 state legislators. So the question would be, what is the proper forum for this type of issue? The second question is in reference to the NYPD, who's recently been surveilling Muslim communities throughout the Northeast, tracking emails, looking at their internet usage. How would this case apply to that, and what could be done with respect to third-party practice as you were discussing earlier.
I certainly don't want to monopolize the discussion. There are people here that know, everybody up here, that a lot more than I do. But certainly having served in the legislative branch, and I know the administration and the Department of Justice is involved in a different arena on the immigration issue. I think principles of federalism are principles of federalism, and simply because a state concludes that the federal government is not enforcing federal responsibilities to the extent that the state believes they should or wishes they should, to me does not give rise to an appropriate exercise of state authority to usurp federal authority any more than vice versa. So I still think that ultimately the responsibility resides with us, the people of this country. We need to me it's much more important to go to the Congress, Republicans and Democrats alike, and say, do something about this, whether it involves a wholesale rewriting of ECFA or a more surgical approach that Jason might seem to favor. At least address these issues and pay attention to this, as opposed to all of the other things that we go to Congress constantly for, a little bit of money for this or that or the other thing or all of the above. So I still think that it is the legislative responsibility ultimately to address these issues. They have woefully failed to do so both at the national and the state level, but to me that does not mean that we ought to ignore those principles of federalism or the separation of powers.
Add to that, Chris, is that this is a situation where there wasn't a conflict between legislative and judicial branches on this issue. There wasn't a statute that said you don't need any process to put a tracker on a car. That was just sort of the way the law evolved. Sort of reading the tea leaves from prior Supreme Court decisions, law enforcement gleaned that as long as they're only monitoring in a public space and as long as they're not entering on a private property to actually put the tracker on, then you don't need any process. The Supreme Court now said that ain't right. So now there's a new rule. But in all the other areas we've been talking about, when it comes to cell phone location information and in other areas, there is a law. Congress has sought to draw those lines. And it's ultimately up to Congress to decide in 2012 whether those lines still make sense, as I think they do, or whether they need to be completely redrawn as others think they do. And ultimately, if the court decides that Congress has not drawn the lines in the right place because of the evolving notion of what a reasonable expectation of privacy is, we'll hear from the court again. But I do think that, as I said at the outset of my remarks, I think that all three branches have a role to play. And speaking just as a citizen, I think it's one of the things that is most privacy protective of our system of laws, that we do have the checks and balances that we have. I mean, as a prosecutor, is it annoying to me when I give a de-order that's 15 pages long that I think has more facts than I need to a judge and have the judge say, no, that isn't enough? Yeah, because it slows down the investigation and I may not have any more facts and I may not be able to use the technique I want to use. As a citizen, am I glad that a prosecutor has to go to a judge and make that showing and the judge is doing her job or his job and making sure that the evidence is really there? Yeah, and all of us should be too.
Just very briefly, this question of who should decide, the states or the federal government, is a wonderful note to end on, because it's a question that the great hero of privacy, Louis Brandeis, would have insisted on. Brandeis was both the defender of privacy and of states' rights, of the states as laboratories of democracy, and he was always suspicious of centralized federal solutions to these problems. The problem in this area, as Justice Alito noted in his concurrence, is it's tough to have the laws vary from state to state. Under the Scalia reasoning, there'd be different property rules in different states, and whether or not a trespass existed would vary from state to state. That's why it does seem like some sort of national solution, whether ECPA reform or a geolocational privacy bill is necessary. And as for the surveillance of Muslim students, of course, this decision only applies to long-term geolocational tracking. Shorter-term surveillance isn't covered, and the question reveals how little racial profiling, as you know, is regulated. The courts have said the Fourth Amendment doesn't seem to regulate it. If there is regulation, it's an equal protection problem, but it has to be intent to surveil on the basis exclusively of race. Race is the sole factor, so it's tough to come up with a constitutional argument against it. Maybe that's another necessary area of reform.
Okay, well, if you would join me in thanking our panelists, and thank you for